I will now call this meeting of the Senate Judiciary Committee to order. Would the esteemed secretary please take the roll?
Vice Chair Cannizzaro,
Please mark her present when she arrives.
Senator Orenshaw,
Present.
Senator Harris,
Here.
Senator Sellemeyer, Senator Hansen, Senator Pickard,
Please mark him present when he arrives.
Chair Scheibel.
Here. All right. Today we have a shorter agenda than yesterday, a couple of bills to work session and one bill to hear. We will start with the hearing on AB 201. I understand we have Assemblywoman Gonzalez in person and then a couple of people with us by Zoom. So go ahead whenever you're ready.
Hello. Thank you so much, Chair Scheibel and members of the committee. For the record, I am Assemblywoman Cecilia Gonzalez, and I represent Assembly District 16 in Clark County. I'm here today to present for your consideration Assembly Bill 201. With me today on the Zoom is Jency Anderson, the legal director of the Rocky Mountains of the Innocence Project. With the chair's permission, I would first like to provide some general background information, and then I'm going to hand it off to Ms. Anderson to go into more details of the bill. Last session, this body passed Assembly Bill 267, which compensated people who are wrongfully convicted. When DeMarlo Berry went to prison in 1994 for a murder he did not commit, it was a jailhouse informant who was an incriminating witness. Based on the informant's testimony, Mr. Berry was convicted and sentenced to life in prison. However, in 2014, the informant admitted that he lied and also received benefits for his testimony. Testimonies from jailhouse informants is one of the leading contributors to wrongful convictions, playing a role in nearly 1 in 5 of the 367 DNA-based exoneration cases nationwide. So, who is an informant? An informant is an individual who provides testimony or information about statements the defendant made while they were incarcerated together. Informants often receive a benefit from prosecutors such as for information, usually in the form of a plea bargain or a reduced sentence on their own criminal charge or even a dismissal on their case. Informants also can receive financial incentives or other special benefits while in custody for their testimony. Chair, with your permission, I would like to turn the presentation over to Ms. Anderson now. However, I did just want to state that this is not an attack on district attorneys in Nevada. However, this bill is to provide provisions so that we can prevent the wrongful incarceration of people using jailhouse informants. And with that, I'm going to hand it off to Jency. Thank you.
Good afternoon, and thank you so much for having me, and thank you to Assemblywoman Gonzalez, senators, chairwomen. My name is Jency Anderson. I am the legal director of the Rocky Mountain Innocence Center. We're a small innocence project that covers Utah, Wyoming, and Nevada, and works to right wrongful convictions in those jurisdictions, as well as prevent them in the first place. And this bill, AB 201, goes a long way in doing that. I also want to thank the District Attorneys Association, as well as specific district attorneys, for giving us incredible feedback on this bill, coming to an agreement on what would be best to support not only the wrongfully convicted, but to make sure that district attorneys are able to use informants when they are reliable, and also to protect those informants should they actually provide testimony. As Assemblywoman Gonzalez said, about 10% of the cases on the National Registry, in DNA exonerations, it's about 20%. On the 2,700 exonerations that have happened nationwide by both DNA and non-DNA, about 10% of those involved jailhouse informants who didn't tell the truth. And Nevada is not immune from that. About 15% of the exonerations that have taken place in Nevada have included jailhouse informants. And one of the reasons I'm here is because I was one of DeMarlo Berry's attorneys. DeMarlo Berry, as Assemblywoman Gonzalez told you, was wrongfully convicted of murder when he was 19 years old. He was convicted almost primarily or exclusively on the testimony of a jailhouse informant who claimed that DeMarlo had confessed to him while they were in the holding cell together. There was no physical evidence tying DeMarlo to the scene. eyewitnesses only one of the 13 eyewitnesses could identify DeMarlo in a lineup. The rest said it wasn't him. There really was a dearth of evidence except for this alleged confession. Richard Iden, who was the name of the informant, claimed that DeMarlo had confessed to him, and in exchange for that, he was given really incredible deals on a plethora of charges that were pending in both Clark and Washoe County. He was flown home to Ohio to spend time with his ailing father, and he never disclosed that information in court. And the defense never learned about that information, and so they were unable to challenge him on the veracity of his testimony based on perhaps the deals that he was given or his desire to come home from prison, even though he was a guilty man. In that case, in 2011, the actual perpetrator to that crime, Stephen Jackson, confessed that he was the one who had indeed committed the murder that DeMarlo Berry had been in prison for. And in 2014, Richard Iden finally came clean and admitted that he had lied on the stand, that he had received all of these benefits, and that he had never even spoken to DeMarlo. And in fact, the first time that he saw DeMarlo Berry was in the courtroom when he testified against him. After fighting for Mr. DeMarlo's release for 4 years, RMIC worked with the newly formed Clark County Conviction Review Unit at the DA's office there, and Mr. Berry was released, an innocent man, but only after spending 24 years in prison. He was issued in 2020 a finding of factual innocence, and he is now living as a free man. But I think those 24 years could have been avoided had a law like AB 201 been in place. It points up the idea that jailhouse informants' testimony is inherently unreliable. And so it's important, in other words, jailhouse informants often have motivation to lie. And so it's important that that information about what deals they may be receiving, about when they say the testimony happened, allowing prosecutors to track that kind of testimony, and allowing those prosecutors then to know if someone is trying to be a jailhouse informant frequently. And so this bill not only sort of recognizes that, but it protects everyone in the criminal justice system. It protects prosecutors from convictions being overturned on grounds that information was not disclosed. It allows them to more thoroughly vet their witnesses. It allows the defense to have that information so that the defense can make decisions about how they're going to deal with the jailhouse informant. And it helps the defendant. It makes sure that if they are indeed an innocent person, the likelihood of them being wrongfully convicted on the testimony of an eyewitness of a jailhouse informant goes down. And it also then, if the jailhouse informant is telling the truth, protects everyone in the system, the public, the victim, so that all of that information is available and is transparent. So really, this bill allows for transparency. It allows for the tracking of these kinds of individuals who give this testimony. And it requires that information be given transparently to the defense so that we avoid wrongful convictions and avoid the overturning of rightful convictions. I'm happy to answer any questions. And we are joined on the phone by Nathaniel Erb, who is a policy analyst for the National Innocence Project, who can also help me if you have specific questions about the bill and or about DeMarlo Berry's case or anything else, that if I can't help you, he's available as well. So thank you again for having me, and thank you so much for your support of this bill.
All right, thank you for your presentation. I'll open it up to questions from members of the committee. Do the members have any questions? It looks like we don't have questions from anybody on the committee. I have a couple. I do want to confirm that when we talk about informants, I know that the text of the amendment doesn't say jailhouse informants, but it does define the informant as somebody who allegedly received this information when they were in custody with the person who allegedly made the confession. So I just want to confirm that we're talking about informants who are offering to provide information from custody, not talking about controlled bys, CIs, or people who are just arrested and are trying to provide information from outside.
Did you?
Absolutely. I'm sorry, you can address that, Assemblywoman. I apologize.
No, you're good. You're good. Cecilia Gonzalez, Assembly District 16, for the record. Yes, that is correct. The definition is just to informants that are incarcerated, and we worked with you, Chair, and the District Attorney's Office and the Public Defender's Office to make sure that the definition is just for people who are incarcerated together at the same time that may be making these statements.
Thank you. And this would also then be limited to sorry. What I'm trying to ask is that this is in addition to the rules of evidence that already apply to a hearsay exception to statements made by somebody, because really we're not talking about a precipient witness. It'd be a very, very unusual circumstance where somebody's both a jailhouse informant and a precipient witness, right?
Yes, and Jenny Noble is here if she can better answer that question, because I do not practice law, but she's here to answer as well. Do you want to? Here she comes.
Thank you, Ms. Noble.
Good afternoon, Chair Scheibel and members of the committee. Yeah, the answer to that question is yes, Senator Scheibel. This would not pertain to precipient witnesses, and it's not designed to replace or extend Brady, Giglio, any of those cases.
Thank you. I think the one question I still have about the bill is about the benefits that are conferred and the cooperation agreement. And the way that I'm reading it, the information that the defense is entitled to and the information that has to be kept by the district attorney's office has to do with the benefits that are written into the cooperation agreement. And I want to make sure that we're specific about that because, in my experience, somebody who serves as an informant may have other benefits that are not conferred by the district attorney's office, but that result from having been cooperative in a case. For example, when somebody, testifies in court, a judge may look upon that favorably. Some people may say that being transported to the courthouse to give testimony is a benefit, but if they have not specifically negotiated as part of their agreement that the transportation to the courthouse is one of the, quote, perks of being an informant, I just want to make sure that we're not opening up the door to require anything and everything under the sun to be included.
Jennifer Noble, for the record, yes, part of the purpose of these amendments is to make sure that we were not including potential benefits or something that a judge might see in terms of the validity or valor to what an informant did. We're talking about a contract, a bargain for exchange between a district attorney's office and an incarcerated person who learned information while they were incarcerated. That's what this is designed to do.
And does this generally conform with the, because I think, I'm not sure if I mentioned it in this committee before, but I know in conversations about this, I've mentioned that at the Clark County DA's office, we have a jailhouse informant policy. We can't just call them in like any other witness. We have to go through an approval process. Does this mirror or follow what are the generally accepted jailhouse informant policies in Nevada and nationwide?
Jennifer Noble, for the record, yes, that's correct, Chair Scheibel. What this is really designed to do is to make sure that the policies already adopted by the vast majority of district attorneys' offices throughout our state survive from administration to administration, and that this information is tracked so that it can be disclosed appropriately.
All right. And just one final question. I'll go to Senator, well, I'll ask my question first and ask very specifically, this information has to be maintained in some kind of database, and who has access to that database?
Jennifer Noble, for the record. So the persons that would have access to that database would be district attorney personnel investigations personnel, and DAs.
All right, thank you. Go ahead, Senator Hansen.
Actually, my question, I think, would be for DeMarlo Berry's attorney, because you mentioned that in the informant got all these perks, but apparently the DA never gave any of that information to you. Is it required right now, under the new policies, or at the time even, that when they make those sort of arrangements with an informant like that, that the defense attorneys, defense counsel, are notified of the, whatever the perks or whatever you want to call them are?
Yes, thank you for your question, Senator. At the time of trial, I was not DeMarlo's attorney. I was only his attorney in the innocence proceeding in the late 2000s. At the time of trial, this likely should have been disclosed under what we call the Brady Law, which is a law that requires any exculpatory evidence be disclosed to the defense. Unfortunately, it wasn't, and Mr. Iden lied on the stand about receiving any benefit. And so, unfortunately, this was a failure of the system on the whole. And as we did our investigation, we were able to learn about this, which is why we approached Mr. Iden to speak with him, and he ultimately recanted his testimony. By then, we had already had a confession from the actual perpetrator. But yes, this is information that should be turned over. And as DA Jenny Noble said, this is information that is now, this bill simply codifies what is required constitutionally and what is actually happening in the majority of DA's offices in Nevada now.
Well, thank you. The question I have, though, is you mentioned that the system failed, but I don't quite buy that it's the system at fault, because the system clearly had something in place. It was an individual or individuals in the prosecution side of this thing that made a conscious decision not to share that. And I don't know. Obviously, I'm not an attorney. I don't practice in these areas. When a individual in prosecution side or whatever deliberately ignores or fails to do that, I realize it can exonerate the individual. But are there actually any penalties for the lawyers? If they deliberately do that, a guy like Barry goes to prison for 22 years, and then the state of Nevada has to pay $5 million, not to mention ruining the man's life and everything else. But it seemed like nobody, the system was at fault, but somebody in that system, nobody's held accountable? Anybody?
Unfortunately, no. I mean, there are no penalties under the Brady Law or under any current laws. There have been, in very egregious cases around the country, instances where the individual who withheld the information, whether it be the informant or whether it be someone, the police or the prosecutors, there have been some consequences for them. There have been issues of disbarment. There has been some obstruction of justice kinds of charges, but generally there is no consequence. And I really think it's important for me to say, there's certainly in that case, the system failed and the system may have been on the prosecutor's side, was on the prosecutor's side, whether that was police and or prosecutors or an investigator for the prosecutor's office. But for the most part, prosecutors are good people who want justice served just as much as we in the defense community or in the innocence community do. And our hope is that by agreeing and working through this bill together, that we can avoid the kinds of things that happened in DeMarlo Berry's case.
Well, I got it. I'm a big defender of the police all the time, but that doesn't mean there aren't occasionally rogue cops, and I would assume that's also true on the prosecution side. And when those situations do arise, and this DeMarlo Berry case has disturbed me since the very first day I heard about it. It still does. Real black eye on the state of Nevada. But it's like nobody seems to be held accountable other than the taxpayers who have to reimburse the guy, and legitimately so, I might add. Anyway, I don't want to chase down too much of a rabbit hole here. Thank you, Madam Chair.
Did you want to respond?
Yes, thank you, Chair. I think it's important in response.
If you could put your name.
I'm sorry, Jennifer Noble for the record. It's been a while since I've been down here in person. As you all know, I'm from the Washoe County District Attorney's Office. I didn't litigate the DeMarlo Berry case, and my knowledge of it is limited. However, I think, Senator Hansen, it's important to keep in mind that a number of factors contributed to what happened in that case, including the fact that the informant in question perjured himself and later recanted his testimony. So there were a variety of factors, including misidentification and other things, that all conspired to create that wrongful conviction. So I'm not aware of any evidence in that case that suggests that evidence was willfully held back from the defense. I just want to make that clear on the record.
All right, and I think Senator Pickard has a question. Go ahead.
Thank you, Madam Chair. In the questioning, particularly the chair's last question and then the talk of accountability spurred one question in my mind. We're creating a list and we're or a database of informants so we can keep track of this data, which I support in theory, but what there's no penalty, at least I don't see a penalty for wrongful disclosure. Now that may be elsewhere, but what if someone either on the police side or the prosecutor side, or particularly on the defense side, willfully discloses the list? If they gain access to that database and then they disclose it, you're putting people's lives in danger. What would be the penalty? It may exist elsewhere in law, but how do we hold somebody accountable for a wrongful disclosure of that information?
Jennifer Noble for the record. Thank you for the question, Senator Pickard. I think it depends on the circumstances, but you have to keep in mind district attorneys' offices have had this information and have continued to hold this information probably since almost time immemorial, since we first started the justice system. So we are very careful to make sure our disclosures are within the law. In terms of perhaps defense counsel disclosing it to their client or disclosing it to somebody who shouldn't know about it, that would be something that could perhaps be part of a civil action. I'm not aware of any criminal charge that would apply there, but I would say that the defense attorneys I work with in this state and the public defenders I've worked with in this building are trustworthy individuals who are not going to break the law and disclose information that could hurt somebody. And we are all privy to that type of information, and that's part of our oaths.
Sure, and I think the events of the last year suggest that there may be some room for consideration of that one individual that steps out of line. Anyway, it was just a thought that came up. I didn't see it. I thought maybe there was something else in law that could help contain that. But anyway, food for thought for the future, maybe. Thank you. Thank you, Madam Chair.
All right, not seeing any other questions, we will go to testimony in support of AB 201. I think we have some people in the room to give support, so including Ms. Noble. I'll let you go first, and then we'll get to the next person in the room for support testimony on AB 201.
Good afternoon again, Chair Scheibel and members of the committee. I want to thank Assemblywoman Gonzalez and Ms. Anderson and Mr. Erb for working with the District Attorneys Association on a bill that I think will help ensure that this type of information, which is relevant to impeachment of a witness, is disclosed appropriately and safely. So we are in full support of the bill. Thank you.
Good afternoon, committee. My name is Jim Sullivan, S-U-L-L-I-V-A-N, and I'm representing the Culinary Union. The Culinary Union supports AB 201 because it would protect Nevadans against false jailhouse informant testimony, which has led to wrongful convictions and cost the state millions of dollars. During the 2019 legislative session, we heard the heartbreaking story of DeMarlo Berry, who did 22 years in prison for a crime he didn't commit, largely due to false jailhouse informant testimony. Unfortunately, DeMarlo is not alone. Bad jailhouse informant testimony has also played a part in the exonerations of Fred Steese, who served over 20 years for a crime he did not commit. Jailhouse informants played a big role in all of these cases, and Nevadans need legislation to ensure that this injustice never happens again. AB 201 does just that. Tracking jailhouse informant use and requiring prosecutors to disclose specific details about jailhouse informants, such as the details of any deal they received in exchange for testimony, and any other cases that they may have benefited from testimony, is smart policy. These common sense fixes will ensure that no other Nevadan has years of their life stolen from them due to wrongful convictions. Last session, the Assembly Judiciary Committee, the Senate Judiciary Committee did the right thing by ensuring exonerated Nevadans were compensated for the time they served due to wrongful convictions. Now, the state must make sure that no other Nevadans have decades of their lives taken from them because of false testimony from jailhouse informants. This bill will help make that a reality, and the Culinary Union urges the Nevada Legislature to pass AB 201. Thank you.
Good afternoon, Kendra Birchie with the Washoe County Public Defender's Office. I won't go into too much of the reasons as to why this is incredibly important, since you've already heard of, in order to ensure that we do not wrongfully convict an innocent person. I would just add, as to Senator Pickard's question, I've spoken to Bar Council because there are some issues involved of we have a duty to disclose information. But this bill does provide requirements where a court could order us to not disclose that information. And I'm not talking about the database, just the specific information. Where as long as the court has a hearing, has a discussion as to why it's appropriate to not, or to require for the defense attorney to not provide that information, there's specific findings and a written order. It's my understanding that does protect defense attorneys so that we are not in violation of our ethical duties to represent our clients. So I just wanted to make sure that you had that information as well. And with that, we do urge your support of this bill. Thank you.
Thank you, Chair. John Pirro from the Clark County Public Defender's Office. We are also in support of this bill. This is an important measure. I will bring up a few things. Jailhouse informant testimony. As you know, Senator Hansen, the state was seeking death against DeMarlo Berry. And if Nevada wasn't slow on the death penalty, like Texas is, we could have executed an innocent man. In Texas, jailhouse informant testimony led to the execution of a man, Cameron Todd Willingham. The New Yorker did a long article on it in 2009. He's innocent. The arson investigator that looked at it is one of the top guys in the nation, and he was like, other forensic arson investigators said, if that guy says it's not arson, it's not arson. So Texas likely executed an innocent man, and Nevada was almost at risk at doing the same thing. So this is a very important measure to protect the integrity of the justice system, and we urge your support. As for Senator Pickard's question, I don't know many attorneys in my profession that have taken the oath that would let something like that get out and put, one, their bar license at risk, and two, other people at risk, even for some competitive advantage, because that's not what we do. Thank you.
I don't see anybody else in the room to give support testimony, so we'll go to the phones, please, Mr. Kyle, for a support testimony on AB 201.
Thank you so much, Chair Scheibel. To testify in support on Assembly Bill 201, please press star 9 now to take your place in the queue. Once again, to testify in support on Assembly Bill 201, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 130, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINESAUNDERS. I'm the Policy Director at the Progressive Leadership Alliance of Nevada. I also just want to echo the sentiments of those who spoke before me and add our support for this legislation to the record. We urge you to act to ensure these common sense safeguards are put in place. Thank you.
Thank you, caller. Caller with the last 3 digits, 037, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Tanya Brown, spelled TONJABROWN. Advocates for the inmates and the innocent. We strongly support this bill. Thank you, Madam Chair Scheibel and members of the Senate Judiciary. We echo the previous comments. When we think of an informant, we think of a jailhouse informant. Seldom do we ever think of a secret witness as an informant. This type of an informant has a financial gain. They only can receive money if there is a conviction. And sometimes the district attorney and law enforcement agencies may not be aware or have any knowledge that their witness is a secret witness, and if the conviction goes through, will receive monies. But sometimes after trial, they could learn that their witness was a possible secret witness. I've provided a conceptual amendment in the exhibits, and I'd like to refer to section 6, subsection 3G. I believe that could remedy this by including the language. If at any time the district attorney receives an allegation of an informant or the state's witness receiving monies from the state witness program, the district attorney's office must disclose the following information or material to the defense as soon as possible. Regardless if the defense has already appeared before the court, is working on appeal, post-conviction petition, writ of habeas petition, or the defendant is in pro se or has no petition or appealing, must be notified. And they should also include, under the G, if at any time the district attorney receives this information, they must notify these individuals. And then there was this one section where it says if in which the informant offered to provide testimony in exchange for a benefit, but
You've reached 2 minutes. If you could wrap up, please.
Okay, yes. In that one line there, it should include if the defendant should excuse for a benefit but did not testify. It should include the language but did or did not testify. I believe that would help with the secret witness as far as being an informant. I think that would be beneficial to this bill.
I'm going to need you to wrap up, please.
The word did. Thank you very much. Have a great day.
Thank you, caller. And for those that have recently joined us this afternoon, we are currently on support testimony for Assembly Bill 201. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 725. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Thank you, Chair Scheibel and committee members. This is Nick Shepak, Nickshepak, Policy and Program Associate with the ACLU of Nevada, here in support of AB 201. While we preferred the version of the bill on the Assembly side, we still think this bill is a good piece of legislation and will do a lot to help protect people from wrongful conviction due to jailhouse informants. Jailhouse informants are inherently problematic and untrustworthy, as we saw in the case of DeMarlo Berry and the 181 other wrongful convictions that were overturned. A jailhouse informant not being truthful can lead to somebody being placed on death row and sentenced to death. Any state that continues to maintain the barbaric, racist, and archaic practice of capital punishment must do everything in their power to ensure that we are not wrongfully convicting individuals, and AB 201 will help with that. We urge you to support this bill, and thank you for your time.
Thank you, caller. Caller with the last 3 digits, 080. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi, Jim Hoffman, representing Nevada Attorneys for Criminal Justice. NACJ supports AB 201. The jury system is based on the idea that if we give the facts to an impartial group of community members, they will figure out what happened and give us a just result. But in order for that process to work, we need to make sure the jury has all the information. If they aren't aware that a witness is actually a jailhouse informant who's getting a lighter sentence in exchange for testimony, that's obviously a very substantial piece of information. If they're missing it, that makes it impossible for the jury to make an accurate judgment and harder for them to do justice. By requiring that this information be disclosed to the jury, AB 201 will help to make our system more accurate and just. NACJ supports this goal, and so we support this bill. Thank you.
Thank you, caller. Caller, please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE. Grant. I support the bill. I echo the other caller's sentiments. I do agree with Ms. Brown that secret witness should be included. I have seen documents in a case at Washoe County DA's office that it was known that one of their witnesses who testified at trial information became known after the trial. The state's witness was an alleged secret witness. The witness contacted the DA's office that she had been contacted by a private investigator, her being a secret witness, and the defense was having a hearing coming up. She basically asked the DA's office what to do. This witness did not go to work, and she did not return to her home until after the hearing. She could not be served with a subpoena, and she did not have to answer under oath if she was paid for her testimony as a secret witness. I support the bill. Please support the bill. Thank you.
Thank you, caller. And once again, for those of you that have recently joined the meeting, we are currently on support testimony for Assembly Bill 201. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 766. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi, yes, my name is Matthew Wilkie, Matthew Thank you so much, Chair and the committee, for hearing this bill. I am not as eloquent as many of the other speakers before me, but I do urge your support. I do truly believe that with with facts, we don't want to send people to jail, prison, death penalty, especially for crimes that they truly 100% did not commit themselves. It's vital to preservation of innocent individuals. We see it all the time. People, years down the line, you find out that they're innocent. And I do believe that this Bill 201 could be one step further to that. So thank you so much. And I urge your support.
Thank you, caller. Caller with the last 3 digits, 338. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Thank you, members of the committee. For the record, Nathaniel Erb, Nathaniel, last name ERB, on behalf of the National Innocence Project. I want to thank the committee for hearing this bill and Assemblywoman Gonzalez to bring it forward. Above all, I want to thank Chairwoman Scheibel and the District Attorneys Association for working with us on this bill to get it to where it is today. Just briefly reiterate all the comments and answers to the questions given by my colleagues. To a couple of questions specifically around which informants are going to be covered by the legislation. Per Section 4 definitions, it would have to be someone who was incarcerated with an individual, is providing testimony, and is going to be receiving benefits. So all those are buttoned together, so it would only be those particular informants. And to the question around disclosure of evidence, that the lists of the records of jail informants would be entirely held by the DA's office. The records, unless there was a breach of protocol or some type of hacking event or something else where folks unlawfully accessed information in a district attorney's office, those lists would never be handed out per the regulations of the bill. It would only be specific information as part of discovery. I thank again all the colleagues and stakeholders who work with us on this legislation, and thank the committee for its consideration.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide support testimony at this time.
All right. Thank you so much. We will move to testimony in opposition to AB 201. I'm not seeing anybody in the room to give such testimony, so we'll go to the phones, please.
Chair, this is broadcast. Please give us just one moment if you would. We're having small technical difficulty with our public line. We'll be back in about 45 seconds.
No problem.
Thank you.
And thank you so much for your patience, Chair Scheibel. We are currently on opposition testimony for Assembly Bill 201. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Once again, we are currently on opposition testimony for Assembly Bill 201. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide opposition testimony.
All right, thank you. We will move to testimony in the neutral position on AB 201. I don't see anybody in the room to give testimony, so we will go to the phones, please.
Thank you, Chair. To testify in the neutral position on Assembly Bill 201, please press star 9 now to take your place in the queue. Once again, to testify in neutral on Assembly Bill 201, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to provide neutral testimony.
Thank you so much for your help. Unless the presenters have any closing comments, okay, come on up.
Thank you so much, Assemblywoman Cecilia Gonzalez, District 16, for the record. I just wanted to say again, thank you so much, Chair, to the Nevada District Attorneys Association, to the Innocence Project, and everyone who worked very diligently, the public defenders and the Culinary Union, to get us to a point where everybody is really comfortable with the bill. Again, this is to prevent the wrongful convictions and really protections for all parties involved when using jailhouse informants. Thank you so much, and I urge for your support on this bill.
All right, thank you. With that, I will close the hearing on AB 201, and we are going to go into a short recess. Okay, I will call this committee back to order. It's the Senate Judiciary Committee on May 13th, 2021, in the 81st session. We are going to move on to a work session today. We have 4 bills to work session. We will take them in order, starting with AB 7. I will turn it over to Mr. Guinan for walks the document.
Thank you. Excuse me. Thank you, Chair Scheibel. For the record, Patrick Guinan. As the Chair mentioned, we have 4 bills on the work session today. We're going to start with Assembly Bill 7. This is a bill that revises provisions relating to gaming. It's an Assembly Judiciary Committee bill brought on behalf of the Nevada Gaming Control Board. We heard it here on the 22nd of April. AB 7 revises provisions related to gaming, including establishing provisions relating to the approval of games or gambling games by the Commission, amending existing law to provide that inter-casino linked systems are subject to the same regulation and control as associated equipment, revising provisions relating to the confidentiality of certain information and data of manufacturers, distributors, and operators, requiring persons who have a significant involvement in the manufacturing or distribution of associated equipment to register with the Gaming Control Board under some circumstances, and repealing laws authorizing certain business entities to place racebook and sportsbook wagers under certain circumstances. There is an amendment for the committee's consideration that was presented by Michael Morton with the Nevada Gaming Control Board when the bill was heard. It's attached to this document. The amendment strikes language requiring a ticket for a live event to display on its face the admission charge for the event, as that language does not adequately reflect the complexity of the various charges and fees that make up an admission fee. Mr. Morton pointed out explicitly that the amendment in no way changes the calculation or collection of the live entertainment tax. That's all I have, Chair.
All right, any questions on AB 7? Not seeing any questions, I would accept a motion to amend and do pass.
I move, Chair.
We have a motion from Senator Orenshaw. Do we have a second? A second from Senator Pickard. Any discussion on the motion? Not seeing any, I will ask those in favor to signify by saying aye. Aye. And any opposed by saying nay. The motion carries unanimously to amend and do pass AB 7. Any volunteers for the floor statement? Senator Orenshaw, it's yours. That brings us to AB 115.
Thanks, Chair. For the record, Patrick Guinan again, Committee Policy Analyst. We're at AB 115 now in its first reprint. This bill is sponsored by Assemblywoman Wynn and others. We heard it here on April 26th, and it relates to domestic relations. AB 115 authorizes one or more adults to petition a court for the adoption of a child. Each prospective adopting adult and legal parent seeking to retain his or her parental rights must be joined as a petitioner. The court may waive the hearing on a petition under certain circumstances and determine that a child has a legal relationship with more than 2 persons. And lastly, the petition must state that there are no known signs that the child is currently experiencing victimization from human trafficking, exploitation, or abuse. Assemblywoman Wynn has offered a conceptual amendment that is attached to this document. The intent of the amendment is to clarify in Section 5.2 that each prospective adopting adult and each consenting legal parent seeking to retain his or her parental rights must be considered by the court as a joint petitioner, and to clarify in Section 5.8 that any parent who has signed a relinquishment shall not exercise or have any rights over the adopted child or the property of the adopted child. That's all I have, Chair.
Thank you. Do we have any questions on AB 115? I see one from Senator Pickard, and I'll note that we have Ms. Surratt on the phone, and I think we have Mr. Walker here to answer questions. So go ahead.
Thank you, Madam Chair. Not so much questions or comment. And I talked to Ms. Surratt at length about this. The inclusion of language in the amendment of a joint petitioner without creating a mechanism whereby a joint petition is authorized, I think, is going to be particularly problematic for the courts. And given the language is broad enough that it is going to include more than just the situations where there is a consenting or a consent agreement to the deal, I'm not going to be able to support the bill as written. Thank you.
All right. Any other questions or comments before I accept a motion to amend and do pass? All right. We have a motion from Senator Harris. Do we have a second from Senator Orenshaw? All in favor signify by saying aye. Aye. Any opposed, nay? All right. It sounds like the nays are Senators Pickard, Hansen, and Settlemyre. But the motion does pass to amend and do pass, and I will take this floor statement. Next, we will move to AB 143. Mr. Guinan.
Thanks, Chair. Assembly Bill 143, which we heard in this committee on May 10th, was sponsored by Assemblywoman Krasner and Senator Spearman and others. It relates to victims of human trafficking. AB 143 requires the administrator of the Division of Child and Family Services of DHHS to designate a human trafficking specialist within the program for compensation for victims of crime, to ensure that a directory of services for victims of human trafficking is publicly accessible on the internet, to develop a statewide plan for the delivery of services to victims of human trafficking, and to form the State of Nevada Human Trafficking Coalition to assist the designated human trafficking specialist in carrying out his or her duties and in maximizing resources for local human trafficking task forces. The bill requires the administrator to periodically review the statewide plan and its implementation for compliance with the established requirements. There are no amendments.
All right, any questions on AB 143? Not seeing any, I would accept a motion to do pass. I have a motion from Senator Orenshaw and a second from Vice Chair Cannizzaro. Any discussion on the motion? Not seeing any. All those in favor signify by saying aye. Aye. Any opposed, nay. The motion carries unanimously. Is there a volunteer to take the floor statement? Otherwise, I will assign it to myself. And that takes us to AB 182.
Thanks, Chair. Patrick Guinan again. Assembly Bill 182, sponsored by Assemblywoman Tolles and others, which we heard here on the 10th, revises elements of the crime of advancing prostitution. AB 182 revises the elements of the crime of advancing prostitution by providing that a person who owns, leases, operates, controls, or manages any business or private property is guilty of the crime if the person first knows that legal prostitution is being conducted at the business or upon such private property due to having been notified in writing by a law enforcement agency of at least one incident of illegal prostitution that occurred at the business or upon such private property, and 2, fails to take reasonable steps to abate such illegal prostitution within 30 days after the receipt of such a written notice. The measure further revises the elements of the crime of advancing prostitution by removing provisions concerning involuntary servitude and the promotion of ongoing education for employees about illegal prostitution. This committee has proposed an amendment which was discussed at the bill hearing. That amendment is attached to this document. It adds new language providing that a person is guilty of advancing prostitution if the person, quote, receives notice pursuant to paragraph A that the illegal prostitution may result in prosecution for pandering or sex trafficking pursuant to Nevada Revised Statutes 201.300 or facilitating sex trafficking pursuant to NRS 201.301. And it adds new language providing that any action taken to abate illegal prostitution pursuant to this section must comply with any other applicable laws of this state, including without limitation the provisions of chapters 118A and 118C of NRS. Those are landlord and tenant relations in residential and commercial properties respectively. And additionally, with the sponsor's approval, Senator Spearman has requested to be added as a co-sponsor of the bill. And that's all I have, Chair.
All right, any questions on AB 182? I don't see any, so I would accept a motion to amend and do pass. There's a motion from Senator Pickard. There is a second from Senator Hansen. Any discussion on the motion? Go ahead, Senator Orenshaw.
Thank you, Chair. I'm going to vote to support, but I just want to reserve my right. There's still some questions I have on the amendment. Thank you.
All right. Seeing no other discussion, those in favor of the motion to amend and do pass, please indicate by saying aye. Aye. Any opposed, nay. The motion carries unanimously. Is there a volunteer to take the floor statement? I will give it to Senator Pickard. And that concludes our work session for today and the last item on our agenda, except for public comment. I don't see anybody in the room. Are you guys? Okay. I do see people in the room to give public comment. You will each have 2 minutes.
Good afternoon, Chair, members of the committee. John Pirro from the Clark County Public Defender's Office. As we're all familiar, sometimes things die on the altar close to deadline day, and as we've been informed, there will be no route to successfully moving forward with AB 395, even if amended. I really do wish we lived in a world where people didn't harm each other, but sadly, we're not there. And as a public defender, every day I'm confronted with the question of how our society punishes the most broken among us. Without a doubt, people who have harmed another person should be held accountable, but this accountability must be fair. The true question is not whether a person deserves to die, but whether we as a society deserve to kill them. And to answer this question, we have to take a look at a few hard truths, because truth and reconciliation are sequential, and you can't have reconciliation without the truth first. The truth is that the authority to kill someone who is in prison for life and is no longer an immediate threat to others is an awesome power, and that power must be exercised humanely, fairly, and reliably. And no matter how we've tried to accomplish that in the state of Nevada, we've been unable to do so. The truth is that for every 9 people executed, 1 person has been found to be completely innocent. That is a shocking rate of error. Some of us would not live through this session if 1 out of 9 planes crashed. And I wouldn't fly up here, I'd drive up here every weekend. And if you think convicting an innocent person is just a national problem, it's not. Here, we did it to DeMarlo Berry when the state sought to kill him. The state sought to kill Fred Steese. The state tried Kirsten Lobato for murder, and the state tried Kathy Woods for murder. And those are all innocent people in the state of Nevada that were freed, and then we paid out millions of dollars later, but they could have been killed. It's hard to put into words how disheartening that is. I'm sure a lot of people feel that way when they bring things up. I'm sure all of you fought for election because you came up here to fight for things you believe in, and we do the same when we come up here. Perhaps, maybe, since the governor said a robust discussion is necessary, perhaps there's a way out with a moratorium. If we're going to discuss things, let's not kill somebody in the middle of discussing things and what's right and appropriate. And so public comment is for this body to consider things, and I would ask this body to consider a moratorium. Thank you.
Kendra Birchie with the Washoe County Public Defender's Office. I'll start by just echoing what Mr. Pirro said. One of the most difficult things as a defense attorney is to go to trial on someone who is innocent. And I cannot imagine doing that with someone who's facing the death penalty, which is why we've been working so diligently this session to try to abolish the death penalty. And we're willing to continue to work and to work on ways to fix our broken system. Capital punishment is a racially discriminatory, arbitrary, and archaic system with grave costs, both morally and financially, because it is fraught with error. Now is the time to hear ways that we can fix this current broken system. Since 1973, 185 individuals across the nation have been sentenced to death, have been exonerated, including Roberto Miranda and Paul Browning here in Nevada, who spent decades on Nevada's death row for crimes they did not commit. Many others have had their sentences commuted to life imprisonment because of serious doubts about their guilt. Tragically, some have been executed even despite serious concerns regarding their innocence. Once an execution has been carried out, there's no chance for correcting those mistakes. On Nellis, you can see all the letters from individuals, businesses, organizations, urging the committee, the Assembly Committee at that point, to pass AB 395. I'll point directly to some of the letters which explained why it's necessary to pass it at this time. The death penalty has also fallen out of favor nationally, including within our own great state. We spent a lot of time talking last session, as well as this session too, about DeMarlo Berry. And I think it's important just to bring him up again as to why we need to do something now. The time is now. And we urge this committee to consider anything, including I cannot say the word right now, a moratorium. So thank you, I appreciate it, and I appreciate your time today.
Thank you. I don't see anybody else to give public comment in person, so we will go to the phones, please.
Thank you so much, Chair Scheibel. We are currently on public comment this afternoon. If you'd like to provide public comment at this time, please press *9 now to take your place in the queue. Once again, if you'd like to provide public comment this afternoon, please press *9 now to take your place in the queue. And once again, for those of you that have recently joined us, we are currently on public comment. If you'd like to provide public comment at this time, please press *9 now to take your place in the queue. Caller with the last three digits, 464. Please press star 6 to unmute yourself. We'll move on. Caller with the last three digits, 715. Please press star 6 to unmute. Thank you, caller, and slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hello, my name is Taylor Patterson, TaylorPatterson. I'm the Executive Director of Native Voters Alliance Nevada and a member of the Bishop Paiute Tribe. And I'm just calling in today to echo the sentiments that were spoken earlier to have a hearing for AB 395. It's important to listen to the constituency, and I think it's very clear that all of us are really resounding that we need to have this conversation, and I'll leave it at that. Thank you.
Thank you, caller. Caller with the last three digits, 963. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Hello, my name is Yesenia Moya, YESENIAMOYA. I would like to echo all the sentiments that have been here before me for public comment. I believe that you need to listen to the constituency. We need to have a hearing on AB 395. We ask for a moratorium on the death penalty till these conversations can be had. This bill is something that has been supported all over the state of Nevada. This is the choice of the people. Do not take the choice of the people away. We are asking you once again to please pass a hearing for AB 395. Thank you.
Thank you, caller. Caller with the last three digits, 039. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Hello, my name is Erica Minaberry. That's ErikaMinaberry. And I am calling to say that it is time for us to hear a death penalty bill. We elected you to do something important for us. I personally knocked thousands of doors in 2018 and 2020 to get y'all elected. I cried in 2018 when we had the majority. And now it's like you guys are playing the best game of Secret Hitler ever, because I really can't tell which one of you is a fascist and which one isn't. This is no different. The death penalty is no different than a continuation of lynchings. And yeah, that's some pretty ripe, strange fruit that we're allowing in Nevada, and it's a disgrace if you guys don't allow this bill to be heard. Thank you.
Thank you, caller. Caller with the last three digits, 591. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi there, my name's Jamie Shepler. That's JAIMEESHEPLER. So I want to start off by saying I'm very, very disgusted with this committee passing AB 286. I do think you guys need the consent of the governed and you should put it on a ballot, but of course you don't care what any of us think. Yesterday I heard you guys discussing AB 400 and AB 424. You seem very concerned with the constitutional rights and liberties of criminals. When discussing AB 400, someone said that just having marijuana in your system does not mean you're guilty. Same goes with AB 286. Just having a home-built firearm does not make you guilty. Dallas Harris, when presenting AB 424, stated it's not always easy letting people have their liberties. She was right. Maybe a home-built guns make some of you uncomfortable, but it is our constitutional right. I do want to say that legislation should not be born out of emotion and fear. It should be based on facts. The fact is, increased gun laws do not stop gun crime. In the states and cities with the strictest laws are the highest gun crime rates. In the cities where they've eased gun laws, gun crime rates have gone down. I also was involved in an active shooter situation, so I know what that chaos and horror feels like. I've also had someone shot in my front yard. One thing I had to come to grips with and realize is that it wasn't the fault of the guns or the gun manufacturers. It was purely the person behind the act. When someone sets out to kill people, they'll find a way to do it. If it's not a gun, it will be a car, at-home explosive device, knife, or some other weapon. I heard a lot of talk of ending gun violence. Gun violence, and more importantly, violence, will never be ended. It's been going on since the beginning of time because some people are born bad. As someone who's helped friends build guns, it's hurtful to have people in this committee labeling, profiling, and stereotyping those who make guns as criminals and extremists, and that's not true. And it's not easy or cheap to build a gun at home. It requires much more than just parts. It requires expensive machinery to make the firearm and lots of patience and time.
And that's
Most
2 minutes,
criminals
so you'll need
get
to
their
wrap
guns
up.
on the black market. Okay, I just wanted to say that as Martin Luther King said in 1963, one has not only a legal but a moral responsibility to obey just laws. Conversely, one has a moral responsibility to disobey unjust laws. This is a violation of our Fourth
All
and
right,
Second Amendment.
you've passed
and it's
2 minutes. So we'll move on to the next caller, please.
Thank you, Chair. Caller, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE GRANT. My brother was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. I had put in a public records request with the Washoe County District Attorney's Office in regards to their conviction integrity committee, and what I got out of that request basically is that it's a dog and pony show. Since their inception, which I was told through the public records request, it was 2018, DA Jennifer Noble testified to Assembly Judiciary is 2017, so I don't know what the truth is, but that since the initiation of the CIC
I'm going
unit,
to ask
they've
that we
reviewed
keep
one
the
case.
comments to policy issues before this committee and not personal attacks on people in the committee, on the committee, or testifying in front of the committee.
Well, this is regarding the CIC unit, and I think that we need legislatively mandated review. So I'd like to continue. Thank you.
Thank you, caller. Caller with the last 3 digits, 261. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hi there. My name is Mary Gilbert, MaryGilbert. I'm here to echo what you have been already hearing, that the death penalty is a continuation of the American tradition of lynching. It demands that it be given a hearing, and I also ask why none of you have the courage to do what's right. You have so much power in your positions. Use your power to demand a hearing, please. I also find it cowardly that no one has expressed solidarity with the Palestinians as they are currently being exterminated. Please do better. That's all.
Thank you, caller. Caller with the last 3 digits, 279. Please press *6 to unmute yourself. And slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hello, my name is Laura Martin, LauraMartin. I'm the Executive Director of the Progressive Leadership Alliance in Nevada. And I just wanted to point out that in my home state of Colorado, all of the Democrats who voted for repeal the death penalty and face re-election won their re-elections except for one person, and they lost that seat for very unrelated reasons. And I say that because it seems that sometimes a lot of these decisions, these tough decisions that we have to make, are held hostage by people's continued political careers. And we really have to ask ourselves, do we want to be a state who kills people? Do we want to be responsible for the deaths of people who cause harm to our community instead of really doing the tough work and getting to the root causes of why this happened in our state? We have the death penalty now. It didn't stop Amari Nicholson from being murdered. It hasn't stopped anybody from being murdered. It still continues.
And we have to make sure that when groups like the Nevada Coalition Against the Death Penalty, who have been doing this hard work for over 20 years, and they are a member group of the Progressive Leadership Alliance in Nevada, we have been having these conversations for decades with people who are directly impacted as victims, as family survivors, and they need to be heard, and they don't need to be ignored in order for an easy political way out. It's truly embarrassing that our legislature that prides itself on being diverse and women-led can't get this right. You still have one more day to save your embarrassment and to save, whatever comes next. But truly, I hope you listen to the community and not think that we can just have a post-election cry fest and then we'll forget. We will never forget if you kill the death penalty bill again.
Thank you, caller. Caller with the last three digits, 695. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Madam Chair and members of the committee. This is Holly Wellborn, Policy Director for the ACLU of Nevada. This is a tough job that you all have, and I'm looking at some of these statements that we're writing and realizing that we found out something incredibly important to us just sort of died without really any clear notice, and that's fine. I understand the pressures. I understand what you face on a daily basis and that this is never easy. But I think Ms. Martin brought up something pretty compelling. All of these movements, everything that we have fought for through this body, through local government advocacy, through litigation, these processes take years. And we were at a point where, like we get to on every other piece of legislation that moves through, where we are ready to compromise and talk about something that gets us at least a bit closer. And we didn't have a chance or an opportunity to do that this session when people were ready to do that. I hope that we can continue talking about this. I think that what Mr. Pirro had brought up, an idea of a moratorium or something different in the future, to continue moving this forward when support for abolition is growing exponentially, that it is time to act and it is time to do something. So we appreciate you for taking this time to hear people out in public comment and hope that we can continue this conversation.
Thank you, caller. Caller with the last three digits, 936. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Hi, my name is Jamila Lewis. That is spelled Jameeelah. Last name Lewis, Lewis. I'm calling today to ask for a moratorium of AB 395. I would like to echo the same sentiments as everyone who came before me. I think that it is really invalidating, foolish, and I think it's straight up disrespectful for the governor and for you all not to support ending the death penalty, specifically because in the state of Nevada, that mostly impacts and disproportionately impacts Black and brown folk. Last time I called to ask that you all support an ending the death penalty, I begged you and I actually pleaded to you. And today I'm not going to plead to you. I'm going to tell you that a sin is a sin regardless of where you stand on that sin, right? So regardless of how you vote today or whatever you do, if you're not supporting the ending of people dying while in incarceration, then you are part of the problem, right? You're also part of the sin and your hand's also in it. So today I hope that y'all do the right thing and push for the moratorium. But if you don't, remember where you stand and remember the elections are next year. Thank you.
Thank you, caller. Caller with the last three digits, 464. Please press *6 to unmute yourself. And slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Courtney Jones, Courtney Jones. 27 states still have the death penalty. Virginia just became one of the first southern states to abolish it in 2021. And I'm asking you all to fight for this bill because we have a humane crisis on our hands. It shows your constituents that you stand with the side of the country that has historically been racist, discriminatory, and unfair to Black communities, poor communities, and more. The death penalty has continually been shown to have immense amounts of racial bias, to be killing innocent people, and unfortunately we have to bring in costs because that's all the legislature seems to care about, instead of human well-being and the right to our lives, the right to live. But if that's the way we want to go, then to quote the Nevada Coalition Against the Death Penalty, eliminating the death penalty, states would have millions of dollars a year to invest in programs that are proven to prevent violent crime, create safer communities, and support those who are harmed by crime and violence. So taking someone's life is nothing small, and we have continually had impacted families tell you all that an eye for an eye is not the way to go. As I'm sure you all have heard, an eye for an eye makes the whole world blind. We are saying that these people are irredeemable and just have nothing, just have no way to come back to the community. And I want to just thank the Nevada Coalition Against the Death Penalty for standing up and continuing to, even when our representatives don't. So I really urge you all to understand and act on community investment to help uplift people so that they can take a step away from violence and return to their community. And most importantly, again, invest in those programs that are going to help us stop the violence. And just understand that if, as our representatives, you don't fight for this bill, that's literally blood on your hands. Thank you.
Thank you, caller. Caller with the last three digits, 037. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Tanya Brown, TONJABROWN, advocates for the inmates and the innocent. I'd like to echo the previous comments made regarding AB 395. But I'd also like to include another person's name that most people aren't aware of, although he wasn't in Nevada. Mr. Ray Crone. Mr. Ray Crone was convicted twice. The first time, he received the death penalty. His conviction was overturned. He received a second trial, at which time he was found guilty again. But the judge in the case, in all good conscience, could not give him the death penalty. There was just something about the case that bothered him, and he didn't want to execute an innocent man should it turn out that way. Well, ultimately, Mr. Crone wound up getting DNA testing, and he was exonerated. And the reason I say it's almost a Nevada case is because the main witness, he was a forensic doctor dealing with dental bites, was Nevada Senator Ray Rawson. It was Mr. Rawson's testimony that got Mr. Crone convicted twice. First time receiving the death penalty, the second time. And then I want to personally speak on another issue, which my brother, who had spent 21 years in prison for a crime he didn't commit, fortunately, nobody was murdered in this particular case, because if there had been someone murdered, there's no doubt in my mind he would have received the death penalty, and he would be on death row. And only to find out 21 years later that the district attorney's office, the prosecuting attorney, had withheld all the exculpatory evidence. That was discovered in 2009 when the judge ordered Mr. District Attorney Dick Gammack to turn over the entire file. When it was turned over, all the exculpatory evidence, all the evidence that would have exonerated him had it been turned over. So,
and you've reached 2 minutes, so I'm going to need you to wrap up.
Okay, well, thank you very much. I just wanted to put my 2 cents in, being someone who would possibly have been personally affected had my brother received a death penalty if something else had gone wrong, and Mr. Ray Crone. Thank you.
Thank you, caller. Caller with the last three digits, 590. Please slowly state and spell your name for the record. You'll have 2 minutes to speak and may begin.
Hello, my name is Makaja Daniels, and I am one of the co-founders of Black Lives Matter UNLV.
and a volunteer with Mass Liberation Project. My name is spelled Micajah. So when we started the Black Lives Matter chapter, it really questioned everyone to think about what Black Lives Matter is and what does it mean. And so maybe you've said it or you stood in solidarity with it, but when it came to racism being diagnosed as a public health issue, did you stand up and give a hearing to address the excessive Black death? We're not even here asking for the death penalty against the people who've been using the death penalty to murder the people in our communities. We're asking for a better way. So if people are irredeemable, what does it say about how irredeemable the people who are currently in office, not even addressing the issue, are? Thank you.
Thank you, caller. Caller with the last 3 digits, 922. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Thank you. Ender Austin III, ENDER, AUSTIN, III. The prophet Micah in 6 and 8 says, "Know, O people, the Lord has told you what is good. And this is what he requires of you, to do what is right, to love mercy, and to walk humbly before your God." My request, my sisters and brothers, is that you would honor this request from the prophet who spoke as an oracle for God with the simple request that we would love justice, do mercy, and walk humbly. It's already been stated that we have challenges here when it comes to the Black Lives Matter issue and persons who have stood up and said that they are in solidarity with the movement for Black lives, but not taking into account the way this disproportionately affects those who God has chosen to kiss more with the sun. Also tells us in scripture, the prophet Isaiah says in the 6th chapter and the 8th verse, he essentially says that he heard the Lord asking, "Who should I send for me?" And the request or the response was, "Here am I, Lord, send me." And my question will there be any moral conviction on this committee to say, I am the one who will stand in the gap for those who have the very least to offer in this situation? Lastly, I will ask you about the American Rescue Plan that lays out a way to reduce gun violence and a way to reduce actual violent crimes in our land. Of all of the things, the evidence-based things that it lays out, the death penalty is not one of them. So my question is, if we're looking at the evidence as to how we can reduce violent crime, where does this fall? Eid Mubarak to my brothers and sisters who follow Islam, and grace and peace to my brothers and sisters who are Christian, and shalom to my brothers and sisters who follow Judaism. God bless you all and have a good day.
Thank you, caller. Caller with the last 3 digits, 366. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
My name is Akiko Cooks, AKIKOCOOKS. I am an organizer with the Mass Liberation Project. So I simply just want to say, if you are for the death penalty, and anyone who helps carry the death penalty out, you are just as guilty as those that you are killing. And you need to think about that. How do we go straight into killing people? How do we go straight into, you did this wrong, so I'm going to kill you? None of us have that power. None of you have that power. None of you should want that power. The power you should want is to fix the root of each problem and why people are ending up where they are. Stop killing people or pay for it. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide public comment at this time.
All right. Thank you so much. That brings us to the end of our meeting, and we will be meeting again tomorrow at 1 p.m. Until then, we are adjourned.